Justice Kagan has our opinion this morning in Case 15-1439, Cyan versus Beaver County Employees Retirement Fund.
This case is about the world of securities litigation. Since 1933, a federal statute, often called the 1933 Act, has required companies offering stock and other securities to the public to make full and fair disclosure of relevant information. That legal requirement can be enforced through private suits. Historically, those suits could be brought in either state or federal court. And if the plaintiff chose to bring a suit in state court, it had to stay there. The defendant couldn't remove it to federal court. Over the years, Congress became concerned about some of these lawsuits, particularly those brought as class actions on behalf of many individuals. Class actions may be an efficient and effective way to enforce the law against companies engaged in dishonest behavior. But they may also be abusive, forcing companies to settle even when they've done nothing wrong. To prevent that kind of abuse, Congress passed another statute with both substantive and procedural reforms. This one's usually called the Reform Act. The substantive reforms applied wherever a 1933 Act suit was brought, whether in federal or in state court. The procedural reforms applied only in federal court. That statute proved to have unintended consequences. To evade its restrictions, class action lawyers began to file their suits under state law. That was possible because most states have laws very similar to the 1933 Act, imposing the same requirements of honesty in the securities markets. But when a suit was filed under state law, none of the Reform Act's various protections applied. As a result, Congress thought it hadn't managed to accomplish much of anything. So Congress tried again, this time by passing the Securities Litigation Uniform Standards Act, which is usually called SLUSA. The meaning of that statute is at issue in this case. We know for sure one thing SLUSA did, and it's quite important. The statute altogether prohibited various securities class actions based on state law. It forced attorneys to bring those actions under the 1933 Act. By doing so, it forced them to meet the stricter substantive standards that the Reform Act had put into place. The question before us is whether SLUSA also did something else. The petitioner here, which is a company charged with securities fraud, says that the law prevents plaintiffs from filing federal law class actions, that is 1933 Act class actions, in state court. Those suits, the petitioner says, have to be brought in federal court instead. The Solicitor General disagrees with that reading, but says that SLUSA does allow defendants to remove 1933 Act class actions to federal court. So a plaintiff can bring a securities class action in state court, but then the defendant can shift it to federal court if the defendant wants to. That's the SG's position. Finally, the respondents, a group of investors who brought this class action, say that SLUSA did neither of those two things. According to the investors, 1933 Act class actions can still be brought in state court, and defendants still cannot remove them. We agree with the investors. Our opinion is based on quite tricky statutory language. I won't go through all the ins and outs, but instead just say that in the end, the text heavily favors the investor's position. The best arguments for the alternative views of the statute are more purposive in nature. The claim is that Congress wouldn't have wanted 1933 Act class actions to be stuck in state court because the Reform Act's defendant-friendly procedural protections don't apply there. But first, this is just not what the statute as best read says. And second, we don't usually expect statutes to do everything that's consistent with some general purpose. Congress did quite a lot in SLUSA by prohibiting various state law securities class actions. It just doesn't follow that Congress must also have prevented plaintiffs from bringing permissible federal law class actions in state court. Today's decision is unanimous.